Assistant Dean for Academic Programs here at the Batten School. I have the distinct pleasure to open Batten Hour for the day today and to introduce one of our amazing Batten students, Chloe, who is going to come up and begin our introductions for the day.
Hi. So Scott A. Williams is a managing partner and founder of Panorama Consulting, a firm specializing in fundraising and management advisory for nonprofit organizations. He has held executive leadership roles in fundraising at St. John's University and Changing Our World Incorporated, a global philanthropy firm and that has helped serve, everyone. A global philanthropy firm and has helped nonprofit organizations raise over $400 million. He has also served in the U.S. Secret Service under Presidents Bush and Clinton. He is an active member of the Charlottesville community, serving as a board member of the Charlottesville Police Foundation and was formerly on the board of the Live Arts Theater. Scott also serves on the board of directors of the Trinity University Alumni Association in San Antonio, Texas. Longtime friends of U.S. Magistrate Judge J. Mark Coulson and his wife Patty, Scott and his wife Susan Braun are residents of Charlottesville and devout Cavalier fans.
Thank you, Chloe. Well, good afternoon, and thank you for giving me the opportunity to introduce my good friend, U.S. Magistrate Judge Mark Coulson. Attended LaSalle University in Philadelphia and received his JD from Duke University School of Law, graduating Order of the Coif in 1991. After law school, Judge Coulson began his legal career as a trial lawyer in private practice at the firm Miles and Stockbridge, focusing on products liability and medical malpractice defense work. In 2010, he was inducted as a fellow of the American College of Trial Lawyers, whose membership is limited to no more than 1% of the lawyers in a state. He was appointed as a United States Magistrate Judge in the U.S. District Court for the District of Maryland in 2014. As a magistrate judge, he presides over initial felony proceedings in the federal courthouse in Baltimore. His routine duties in that capacity include search warrants, initial appearances, arraignments, detention proceedings for individuals newly charged with one or more violations of federal law. His civil duties include conducting civil settlement conferences in a wide variety of cases, including handling discovery disputes and managing his own docket of cases. Judge Coulson also teaches civil procedure and advanced trial advocacy at the University of Maryland Carey School of Law. He and his wife, Patty Flowers Coulson, are proud parents of 2 adult sons, one of whom recently earned his graduate degree from the University of Virginia School of Education and Human Development. Please join me in welcoming today's Batten Hour speaker, my dear friend, the Honorable Judge J. Mark Coulson. There we go. Thanks,
I couldn't have written it better myself. Wait, I think I may have written just some of the better stuff. So thanks for having me, everyone. I'm Mark Coulson, United States Magistrate Judge in the District of Maryland. Just a couple of housekeeping matters. My comments today are my own. I do not speak for our court. I also want to make another point, we have all certainly seen examples of misbehavior at various parts of the law enforcement apparatus. But my experience with our court and the observations that I have today are based on the fact that I think our partners and our constituent groups are acting in good faith. I have not had any issues with the United States Attorney's Office, federal law enforcement, federal public defenders, and certainly not my judicial colleagues in my district and other districts. I've never had any suspicion that these are not good faith actors. The point of my talk today is that even when everyone is acting in good faith, and even when everyone is acting to try to get to the best decision possible with the information, there are still going to be consequences and impacts on others. So even when it's quote unquote done right, there are going to be impacts in various parts, both the local community, certainly on the individual who's charged, perhaps on other individual community members. So that's really the overall point. In some respects, it would be easier to say, oh, well, it's a broken system. And if we just kind of fix this part and it functions as it should, all will be well. What I'm saying is my experience has not been with a broken system. It's been with a system with men and women working very hard and in good faith. And yet we still will see impacts depending on how certain decisions are made. So I wanted to explore those in our hour so that those of you who are interested in policy change will understand how the system works together and will make decisions about where you can best deliver the most impact for your particular area of interest. If you don't understand how those pieces fit together and you stand from the outside and just want to kind of shout at it, then you are not going to get the kinds of changes that you might be seeking, again, depending on your policy area of interest. So with all of that, notice the Duke blue on the... I'm trying to build bridges here. Mediation is one of the things I do. So let's get started. Let me change handheld electronics here. So just a quick overview, particularly for non-lawyers. Actually, I should probably ask, do we have any lawyers in the crowd? Do we have any? Oh, there's one. The dean is here with us. Very nice to see you. Any law students in the crowd? Aspiring law students? Right. Depends on whether I have a better option, but maybe I'll wind up in law school. That's fine too. But let me give you an overview. And I give you this because I have to admit, when I took the job as United States Magistrate Judge, and I was coming primarily from the state civil personal injury defense world, it had been a while since I paid much attention to how the federal system worked, especially on the criminal side. So let's just talk about a couple of things. When we talk about federal criminal law, I will tell you when I first took the job, I thought that would be stock fraud or tax problems or maybe environmental concerns, antitrust issues from the Department of Justice, perhaps broad civil rights relief. What it is mostly in our court, and again, I'm based in Baltimore, and most of our cases are coming from the greater Baltimore metro, particularly Baltimore City. Instead, what we see are crimes that you might otherwise think would be prosecuted on the state level: drugs, guns, drug conspiracies, and things like that. So some of the players include all of the alphabet law enforcement agencies. So I'm regularly dealing with the DEA, FBI, IRS, Homeland Security, ATF, certainly Department of Justice. These are all federal statutory offenses. However, the federal statutory code has made federal crimes out of what normally would be considered state street crime, for lack of a better word. So there is, for example, a federal statute that deals with drug distribution. There's a federal statute that deals with possessing a firearm by somebody who's been previously convicted of a crime. There are federal statutes dealing with robbery of things that affect interstate commerce, which these days almost all do. So if someone robs the cell phone store in the mall down the street with a gun, that could very well, that would violate, given federal statutes, it probably would also violate a number of state laws. So how do these cases get brought? The charges are brought in the federal district court where the activity occurred. Now, most states have one district. Some bigger states have several. Virginia actually has two. They've got the Eastern District and Western District of Virginia. Now, within those districts, sometimes there are a number of different courthouses. So here in Maryland, we have one district, but we have two courthouses. One is down in Greenbelt by the DC metro area. The other is in Baltimore City. In Virginia, we're here in the Western District of Virginia, but you have courthouses in Harrisonburg, Abington, here in Charlottesville. I'm probably leaving one out, but it's the same kind of thing. One court, but several courthouses. But in any event, the charges are brought in the district where the alleged activity occurred. They are brought by the United States Attorney for that district. United States Attorney is part of the Department of Justice. They work for the Attorney General of the United States. So each district will have one head U.S. attorney and then several assistant U.S. attorneys. Those are the folks who are doing the filing decisions and the charging decisions. Those are the folks who are assisting federal law enforcement in the investigating of the crime. Those are the folks who are interacting with the court to the extent the court needs to be involved with that. So these decisions are all being made in the executive branch of government, right? So we do remember 3 branches of government, at least last time I checked. And they are being done by the executive branch. We, of course, are in the judicial branch. I said before that you could have the same kinds of activity could violate federal or state law. And so then you might ask yourself, well, then how do we decide where those charges get brought? Well, where those charges get brought largely is up to the charging authorities. So sometimes there is coordination. Sometimes there'll be a task force, for example. The DEA and, say, the Baltimore City Police Department will form a drug task force with the idea of going after drug distribution crime in greater Baltimore. When those cases are ultimately charged, I'd say most often they would be brought into federal court. But there's also on any given day, there are just 2 independent law enforcement apparatuses at work in any given place. So there's not always coordination. And there are, in some places, it's just as likely you might be charged in the state as in federal court, depending on who's looking at you or investigating when you fall into their radar. Sometimes a case will start in state court, and then there'll be a decision made to take it out of state court and charge it federally. There can be ramifications to that. In our district, I will talk about some of those ramifications. If you are charged in state court for a crime that was alleged to have been committed in Baltimore City, you ordinarily would go to Baltimore City Circuit Court. Your jurors would be residents of Baltimore City. They would hear your case. There would be, state courts have their own length of time that things take, and they have their own decision-making process. If you were convicted and sentenced, you would be going to a state facility somewhere. If that same case is brought in federal court, 3 blocks down the street, then you're going to have a jury pool that's from all over the state. We pull almost every county in Maryland into our pool. It is somewhat common to have juries with complete geographic diversity. So if you are a Baltimore City resident being charged with a crime in Baltimore City, your jury would be your neighbors in Baltimore City. If you have that same crime brought in federal court, you're going to just as likely have someone from, say, far western Maryland or the Eastern Shore or the Baltimore Metro as your juror. The sentencing in federal cases tends to be longer. A lot of it is controlled by the federal sentencing guidelines. We also have no parole in our system. So if you get sentenced to 11 years in federal prison, you can accumulate a little bit of good time credit. I think it's up to 54 days a year. But other than that, there's no kind of parole system where you serve a third of your sentence and then get released and might be on probation for a while. So that obviously can be a difference. We also don't have suspended sentences. So sometimes when I look at someone's criminal history, I'll see that they were convicted in state court for armed robbery. They were sentenced to 14 years, all but 6 months suspended. So that they carry the stigma of the sentence, but they haven't actually served the length of the sentence in prison. Federal court, we don't handle it that way. So again, here's a decision just based on the location of where your charges are going to be brought that could have enormous consequences certainly to the charged party and to others. So how do we divide up labor here on the court? So there are United States district judges. Those are the ones you read about in the paper. Those are the ones that have the confirmation hearings where, you know, there's some back and forth, sometimes heated discussion. They get followed. So they must be nominated by the president and they must be confirmed by the United States Senate. They can handle all aspects of a felony criminal case by Constitution. They are Article 3 judges, as we say, and therefore they can do felony criminal trials. Then there are U.S. magistrate judges like me. Now, there are federal misdemeanors. I can handle all of those. We actually are the busiest misdemeanor docket in the country in Maryland, despite our small stature. Federal misdemeanors generally are low-level state crimes, but they get committed on federal property. So we have a number of federal facilities, NIH, FDA, Aberdeen Proving Ground, Joint Base Andrews, Fort Meade, NSA. the BW Parkway. So if you get your speeding ticket traveling between Baltimore and Washington on the Parkway, it's the U.S. Park Police, and you come into the Greenbelt Federal Court. And often those crimes carry what some might argue is an outsized potential sentence. You have expired registration, for example. Potentially that's a year-long federal incarceration. Now, we don't have many folks who are serving any time on federal misdemeanors, but again, depending on where you're committing your crime, you could face different kinds of consequences. So we do those cases. We usually do those on like one day a month. I will go to Aberdeen Proving Ground up in northern part of Maryland. It's a military base, and I'll sit for 4 hours and hear illegal crabbing on the Bush River, failure to display a valid driver's license, sometimes a drunk driving, something like that, but traffic-like offenses. We also will do all of the investigative work, even on felony cases. So I do criminal duty once every 5 weeks. There are 5 of us when we're fully staffed in Baltimore. We rotate that duty. If I am the duty judge for the week, I get all the search warrants for the district that don't otherwise go down to Greenbelt. So last year we did 2,000 search warrants, roughly. The last time I was on criminal duty 2 weeks ago, I did 43. So we have a very active search warrant part of our criminal week. And as Scott mentioned, we also do the preliminary matters in felony cases. We'll do an initial appearance. If you're newly charged, you need to have an initial appearance as soon as possible. That generally means the same day that you're brought into custody. We will also do pretrial release and detention decisions. At the state level, these are kind of bail determinations, but we, at least in our district, don't really have a cash bail system. I'll talk more about those decisions and how they're made. So the magistrate judges do all of that. In our court, if you are detained pending trial, the average length of detention is more than a year until you get your trial, where you'll be in a federal detention facility if you're detained. Or you could be out in the community with certain conditions of release. There are some other preliminary things that have to happen in felony cases. There's an arraignment process where you enter your initial plea to the charges, some other matters that are relatively straightforward. But in terms of my duties on criminal week, from my perspective at least, the search warrants where I'm sending federal agents potentially into a residence and the pretrial release and detention decisions are certainly the most weighty on me and the ones that make those very impactful weeks, both on the judges and certainly on the folks who are before me. All right, so when I talk about local community impact, we've already talked about a couple of these, but what kinds of crimes are going to be investigated and where are we going to investigate them? So I talked a little bit about our docket on the criminal side. We have probably 80+% of our cases are drug and/or drug and gun cases. So bringing those in federal court, as I mentioned, has consequences. Also, where we choose to investigate those crimes has consequences. So if the DEA is investigating drug distribution and they decide to do that in Baltimore City, obviously that's where the impact is. If the DEA wanted to investigate drug distribution up in Coulson, where I live in Baltimore County, I'm sure they would find drug distribution up in Baltimore County. But by deciding to aim resources at different places, again, it will affect who ultimately gets charged. You know, those priorities are not for the court to decide. And I'm sure that a lot of thought goes into the best use of resources, but that is an example of community impact. The deployment of tools such as search warrants. One of the first things that we did in magistrate judge training, actually the first 10 minutes of the training, when we walked in as fresh new magistrate judges, they showed us body cam video of a search warrant getting served. And it is served with great force. And that is a picture that I keep in my head every time someone puts a warrant on my desk and says, is it okay? Because once I sign it, that's what's going to happen. It's not always into a residence. Sometimes we're tracking a vehicle or something like that. But it is an intrusive, forceful process in many cases, and something that I always keep in mind. Who is going to get charged? At what level are we going to decide the level of drug distribution is worth the resources that it will take from law enforcement and the courts? Again, those are decisions by the executive branch. The bail decision obviously has impact on the folks who are either being detained or not, also impact on the community. If I let somebody out on release conditions and they come back to the community where they're alleged to have been committing crimes, there's impact on both sides of that. Disposition in terms of the trial and the verdict, and also the sentence, and then post-conviction in terms of the reentry resources and probation. So I put the ones in red that I'm directly involved with, but I thought it was important to keep in mind the laundry list of ways that the federal criminal system could potentially impact any community. Here's what we don't do. I don't decide who gets to be investigated, how they build the case, what charges will be brought, where they're going to be brought. I don't participate in the prosecution. Guilt or innocence is usually by jury and not judge. So we are a separate branch of government. That's not to say that I don't deal with the U.S. Attorney's Office on a daily basis when I'm on criminal duty. I definitely do. But I will, usually tongue in cheek at times, say to them, remember, I do not work for you. I am in a separate branch of government. So I certainly view my job as a gatekeeper, not as a facilitation of prosecution. Now, that's not to say that I put up barriers that aren't justified, but during my criminal week, I essentially am the Fourth Amendment in the District of Maryland, and I decide whether or not a search warrant gets signed. I am the one who's going to interpret the Bail Reform Act in a way to detain or not detain. So they are free to make their arguments. They have their job to do. Again, I think they do it in good faith, but I am the gatekeeper in that process. Let me talk a little bit about search warrants, and then we'll talk more about pretrial detention. Anybody have any questions to this point? They are encouraged. Yes. Oh, yes. So when we have our initial appearance, here are the things that happen. So the person comes in, we can actually we'll do a little fake one right now. And I'll say, good morning, Mr. So-and-so. You're here in federal court today because a grand jury of our court has returned what's called an indictment. Now, an indictment is a charging document, and in it, the government has made certain allegations about possible violations of federal law. So today, I'm going to let you know exactly what you're being charged with. And I'm going to also let you know what the maximum penalties would be if the government were to prove its case. I'm going to talk to you about two important constitutional rights that you have. And then we're going to decide what happens pending your next court appearance, right? So that I explain what's going to happen. The next thing will be that I'll go through the charges. So I'll say you're charging count one with, violation of what's called Title 18, United States Code, Section 922G. Now, what that is possession of a firearm by a previously incarcerated person. I'll go through that. If convicted, this is what the penalty would be. Then I'll go through the Fifth Amendment rights of non-incrimination, then the Sixth Amendment rights to counsel. And then I will say, as part of that, if you can't afford counsel, the court will appoint counsel. Would you like the court to appoint counsel? They will almost invariably say yes. The vast, vast majority of our folks have court-appointed counsel. They submit to me what's called a financial affidavit so that I can see if they qualify for appointment. Almost all of them do. And then I will appoint then and there. We have the lawyer there at the initial. I will appoint that person. As a practical matter, they've already met that person. That person has met them in our lockup, and they already have the beginnings of a relationship established, but that's how they get counsel. I will say there are some districts that don't appoint counsel at the initial, but we do. And one of the main reasons that we do is because we think it's important as soon as possible that folks start to understand what their next steps should be and understand what's available to them. But maybe as importantly, we think that for purposes of a detention hearing, it's vitally important that you have counsel present. So that's when we do that appointment. We do appoint the Federal Public Defender's Office. I will say it's not like TV. So your image of the harried public defender with too many files, and this is Mr., and they're looking for the name. It's a very high quality office with very high quality lawyers. They are overworked. I'm not saying that they're not. We have about somewhere between 500 and 600 criminally charged folks every year coming into the system. They have resource issues just like many other offices, but they are excellent lawyers. And the head federal public defender just does a phenomenal job. So that part of it's not like TV, but many of our folks are represented by that office. Occasionally, if you have multiple defendants, you can't have the federal public defender represent everyone. So we will have what are called CJA counsel. These are private lawyers who have agreed to court appointment. And they get paid, not a market rate, but they get some compensation for that work. So they're kind of our backup if the federal public defender, and they're excellent as well. Any other questions before we talk a little bit more about warrants? So I talked before about the volume and the fact that some of these are quite intrusive. You may have heard on TV debates about so-called no-knock warrants, where law enforcement just kind of breaks down the door. They are relatively rare, as are after-hours warrants. Generally speaking, search warrant must be served between 6 a.m. and 10 p.m. Generally speaking, you're not going to have a no-knock entry. If they want that level of entry, they're going to have to separately justify it in their search warrant affidavit application. I will say they don't request it often. Where it is requested, it's mainly in situations of high danger to the law enforcement going into the particular location. For example, if it's say a dedicated stash house with an organization that's heavily armed, that they've been watching for a year and they can establish that, they might ask for that kind of a warrant. But if it's a private residence, if somebody's living with their family or a grandparent or something, then likely they're not going to get that permission. How does this all work? They submit a form, which is an application. They submit a proposed warrant, which tells me what they're looking for and where. And then it's supported by an affidavit sworn out by law enforcement. The affidavit generally is quite detailed. So I would say even in a very kind of straightforward warrant, you're still going to have a, say, 12-page affidavit. Not uncommonly, it'll be a 40-page affidavit. And the probable cause standard is what I'm looking for. So I get the question a lot, how often do you turn down search warrants? And I will say this, not very often, but here's why. The warrants are generally drafted by the U.S. Attorney's Office. They understand what the probable cause standard is. And so it's not just an agent who kind of gets a wild notion to go into a place. They have to coordinate that with an attorney at the U.S. Attorney's Office, and they know the facts that they need to justify the probable cause. So that's not to say that we don't turn some down. We do. And it's not an uncommon conversation. I'd say at least once or twice a week, I will call the U.S. Attorney and I'll say, well, you've got probable cause for, say, to search this telephone, but I don't find enough to search this second telephone. Do you have any other additional facts? Sometimes they do, and sometimes they don't. So again, that's my determination is probable cause. This is just the laundry list. It's the busiest slide, I think, in the deck. But just to give you a notion of some of the things that we're routinely granting search warrants for: homes, vehicles, businesses, DNA sample, tracking of a phone, go into a computer, go into a telephone, get someone's email. There are location devices that law enforcement uses to track where a person is by cell. So they will essentially drive around with a device that simulates a cell tower, and if the number bounces off it, then they can locate it within a fairly narrow area. Social media accounts are more and more common. So Facebook, Instagram, whatever, you'll need a warrant, but they can get whatever is available. So beyond what's public, this will get them a response directly from, say, Facebook or Instagram, Meta, with the contents of the account. There are also warrants asking for what I call unconsciously shared information. So when you scroll through that license agreement and you click yes, you're sharing a lot of information, including probably where you are at any given time. There are some, I won't say battlegrounds, but there are some of the cases in the courts are arguing a lot about what the showing needs to be. So we will get a warrant, for example, that says there was let's say an armed robbery that occurred between 2 a.m. and 2:15 a.m. on this block. And they asked for a warrant for all, from Google, for all cell phones that have Google on them that were in the area during that time period. So again, there are Fourth Amendment concerns about that. That's casting a broad net. And we'll see what happens with how that ultimately resolves. I will also say that the voluntary sharing of information. So I think the original business model, I'm not in the tech world, but the platform gathers the info so they can sell it to advertisers. Well, they can also sell it to the federal government. So if people want to know the kinds of things you've been looking at, interested in, trying to buy, that information is out there. They don't need a warrant from me. It's out there for sale through your permission when you signed up for the application. I see everybody's deleting. No. It's too late. Do I hear a helicopter? No. All right. So the process is not adversarial in a sense. So there's not another side there. I get the warrant and there's no defense lawyer. There's nobody representing the target at the time that I'm considering the warrant. I'm the adversary, right? I am the one who's going to decide whether or not there's probable cause for the warrant. So to the extent that a warrant was granted that shouldn't have been granted, the remedy is on the back end, suppression of the evidence at the trial or at the investigation, right? So that ultimately, there'll be an opportunity to do that. Generally speaking, it's not at the front end. There is a specificity requirement. There is a timeliness requirement. So if a person sold drugs to an undercover 6 months ago, and the government says, therefore, I want to track their vehicle today, that's not going to meet the timeliness requirement. If they purchased drugs, an undercover purchased drugs this week, then probably it will meet the timeliness requirement. Again, they're drafted by the U.S. attorney, so they're almost always granted eventually because they know what the standard is. There are some other tools out there that are something less than a search warrant, but nonetheless require sometimes approval by me. There's something called a pen register, so they can get every number that your cell phone called or texted. It doesn't give them content, but it gives them that information. There's something called the Stored Communication Act that will give them, I guess, what I would call subscriber information. So if you have an Apple account and it's associated with a credit card and an address and a telephone number, they can get that information with some approval by me. And then they can, on their own, without my approval, send subpoenas to various people, banks, some of the service providers, and they do not need my approval for that. Again, it's limited in scope. It's not as intrusive as a warrant, but there are tools out there. Let's pivot to release and detention before I do questions about warrants. All right. I tell my friends and family they get the 15-minute rule if I sign a warrant with their name. No, I don't do that. I can't. Kid would never do that. Yes, here's a question. So I can't speak to the local and state court. They have a whole different process and they have their own approvals. Occasionally I will see a warrant where I'm kind of the renewal of something that's been initially approved by the state. I'll say sometimes it's a little bit less than clear to me what that process is. I think it depends on the jurisdiction. But yes, these are federal warrants from federal law enforcement. Yes.
You said that technically you're likely to not sign the second warrant immediately and issue it back. Is that typically the case since the city issued back over the law?
I would say it's a combination in that the facts I'm looking for are based on a legal requirement, right? So let's say a specificity requirement. That's a legal requirement, but I need facts to meet that requirement. You know, a lot of times there'll just be kind of a missing piece. Like I'll be reading a warrant and I'll be like, it'll be about a telephone number. And then like on page 39, like here's a new number. I'm like, whoa, where did that come from? Like whose phone is that? Or who is this new person? Because warrants are often in some ways building on each other, right? So the investigation will go on sometimes a year or more before the arrest. So they'll do kind of warrant number one, and then they'll find another member of the alleged conspiracy, and then they kind of give me everything they gave for warrant number one, and they'll now want warrant number two. So sometimes when they're doing that kind of, not cut and paste, but that process, they'll leave something important out. And, you know, then generally we'll work through that, or I'll just deny the warrant. There are some districts, my understanding is there's some districts where they don't tell the government why they just deny it. And they're like, you figure it out. Because we have so much warrant activity, that kind of trial and error, like, I don't want the same warrant with the same problem. Is this right? Is this right now? You know, I'd rather say this is why there's no probable cause, and either there will be facts or not. So someone could rightly say, well, wait, what if the affidavit's incorrect or aspirational? Again, in my experience, the good faith of the affiant is a given, and we've not been kind of shown facts to the contrary. We do get the warrant returns, which isn't a great check. Just because I found something there doesn't mean you should have looked there. But I will say that I don't have some nagging notion that the person who's signing and swearing out this warrant in front of me is telling me a lie. You know, if they are, then I guess they are, and, you know, shame on me, but that has not filtered back through the system, certainly at the federal level. There certainly are examples of that. We had the gun trace task force in Baltimore. You in our state courts, state system. All those folks eventually, by the way, were charged in our courthouse. So we did have some experience with them on the other side. Let's talk about release and detention. As I mentioned, we don't have the traditional cash bail system like you might be used to from TV or from state court. Instead, we have something called the Bail Reform Act. That's a congressional statute that was passed and essentially substitutes an assessment by me of flight risk and danger to the community if released, as opposed to cash bail. I'd like to say we were kind of ahead of the curve with this. Bail Reform Act has been out since the 80s. There are still some federal districts who do have a cash component. Almost all of our defendants are indigent. I've just appointed them counsel because they have no money. And now for me to say, oh, well, you can go home if you can find a $100,000 bond. The few times that I have added a cash component has been for a rich person who I think might run, right? So they've been brought in on, say, a stock fraud or something like that. They have resources, and I might have them pledge a residence or pledge cash because there's a flight risk because they have resources if they are otherwise released, but it's not commonly part of our decision-making. There are criteria under the Bail Reform Act. They are somewhat general, but let me give them to you. The nature of the offense, what kind of charges are we talking about? What they call the strength of the proffer. How strong is the government's case at that point? History and characteristics of the charged person, criminal history, employment, ties to the community, addiction history, things like that. And whether or not they were on release at the time of the new charge conduct. The theory being someone put you on release before and you weren't able to comply. So should be a factor for me in determining whether you can comply this time. There are some charges just by their nature that carry what are called a presumption of detention. For better or for worse, in our district, almost all of the cases that are brought have a presumption of detention because a drug crime with penalty of greater than 10 years has a presumption of detention. That was part of the anti-crime legislation in the 1980s that is still with us. Now, it is a rebuttable presumption. It does not change the burden of proof, but it does impose a burden of production on a charged person that they otherwise wouldn't have. It is the government's burden to prove detention. So to prove that there are no combination of conditions that could adequately assure appearance and could adequately assure community safety. That is their standard. On the community safety piece, they have a clear and convincing evidence burden, which is a heightened burden. So how does this all work in reality? The detention hearing doesn't usually happen on the same day as the initial appearance, but it usually happens within a day or two. Sometimes it does happen on the same day if the defendant would like to do it then, and or if it looks like there might be the possibility of release. I'd rather release a person on day one rather than wait 3 days and have them be in detention for 3 days. We don't have an evidentiary hearing in the formal sense. The government will kind of give a narrative of what the evidence is to date and the pluses and minuses of the release argument. The defense can do the same thing. What am I given ahead of time? There's a report by what are called our pretrial services officers. We'll have very basic information. A lot of that information is by self-report. So if I ask a charged person, do you have a substance abuse problem? And they decide it's in their best interest to say no, it will say no. They try to check that with a family member to see if they're getting accurate information. So they're doing their best, but again, it's a condensed time period. So this person has come into custody, say at 9:30, we may be having a detention hearing at 1 o'clock. Maybe we're having it the next day. So it is usually not a lengthy report. I do get criminal history. That's easy because they can get that off the computer and, that usually makes up a large portion of the report. Most of our folks who are coming in as newly charged in the federal system have at least one felony conviction. About 1 out of 5 have at least 5 felony convictions before they've come into federal court. So that's information that is at least a piece of the puzzle, but I try very carefully not to make it the whole puzzle. It is a high stakes decision with very little information, done pretty quickly. High stakes in the sense that, as I mentioned, folks are going to be in pretrial detention for quite a period of time if they're detained. These are folks who, remember, haven't been convicted of anything and are presumed innocent of their charges and are going to be in a federal detention facility. When I got back from my 1 week of training, the first thing that I asked was to go to the federal detention facility so that I understood when I detain somebody, this is where they go. This is what it looks like. This is what it's like. Our main detention facility, it's called the Chesapeake Detention Facility, which sounds a little bit like a spa or something. It is not. It is a former former state maximum security prison that the Marshal Service rents back from the state. So it is not a nice place to go. All right, so I've got these criteria from Congress. I've got this information from pretrial services, and there I am trying to, what's the right thing to do here? What I have come to here in year 11 is this question: can I put enough resources around the charged person so that they can be successful on release? I have to look at that not only from their success, but also from the community's success. That is, if I put this person back in the community, are there safeguards that I can put in place that can adequately assure the community safety and also adequately support the defendant through release? I say here, I'm blessed. I only put that in quotes because I know that it wasn't just Providence that these tools are in place. It takes a lot of work from pretrial services to develop these options and these resources in the community. But for example, from the bench, I can order a 28-day drug program. No waiting, no, is there a bed? Do they qualify? They have contracts with 3 or 4 facilities, and I can make that happen. I can order mental health treatment from the bench, and they're going to be put into mental health treatment. So I've got tools that I can bring to bear. I can do location monitoring so that we can confine someone to a residence, or we can restrict their activities to certain approved activities. So there are tools. They will have a pretrial services officer who is supervising them during their pretrial release. I have tried to kind of develop a gut for this, and I will give full credit to my wife, Patty, and my friend, Scott, for helping me develop this gut. On paper, a lot of the folks who come before me look very similar. Multiple felony convictions, perhaps a history of addiction, same kinds of charges. Usually a mountain of evidence has been collected even before the arrest. And as I'm looking around the courtroom or I'm thinking about a release decision, I am looking for helpers. Who can help this person stay compliant, and at the same time, they're helping the community with any community safety issues. I look for family. I've learned that family is not just blood family. Look for friends. Look for that one stable person in their life. Maybe they've got a brother who's in the military. Maybe they've got a grandmother who worked for MTA Transit Authority for 30 years and is now retired. Maybe they have a religious person in their life. Maybe they are involved in a mentorship program. We have programs in Baltimore that get involved with folks. And when they show up at the detention hearing, I know I've got an extra level of help and the help with compliance. Sometimes it's a family friend, sometimes it's an employer. When I see those folks, that helps me with my decision. So that's probably a big area where I've learned to really broaden my thinking beyond the statutory criteria. The easiest thing in the world is for me to detain someone. It's not easy in the sense that morally that's not easy, but in terms of will I get in trouble? I will never get in trouble. They can appeal my decision to the district judge. I will almost invariably be upheld on that decision. I'll never be in the newspaper. You were the judge who let this person out and look at what they did. But for me to be in the newspaper for a day versus somebody to be in detention for a year and a half, I can take the heat. So these are not easy decisions. If I do decide to detain somebody, it's sometimes very dramatic in the courtroom. Sometimes there's a lot of anger. There's always emotion. Sometimes, for whatever reason, if I have a very young person, I'm having more and more 19-year-olds, 20-year-olds, 21-year-olds. You're sending that person away to the federal detention center. That's not a good day, even if I'm convinced it's the right decision. All right, some differences. Again, I point these differences not to say that we are better than others, but just to say different districts have different challenges. Different districts have different resources. Different districts have different law enforcement priorities. So some of the differences, we do have counsel appointed before the detention hearing at the time of the initial appearance. Not every district does that. We do not have a cash bail almost ever. In other places, there is more of a posting of property, posting of as part of the picture. The national pretrial detention rate as of September of 24, it's about 71%, 72%, but it varies greatly by circuit. The lowest is the Second Circuit up in New York with a rate of 50.2. Highest is the Fifth Circuit, almost 85%. We are in the Fourth Circuit. We are at 55.4 as a circuit. Our district is at 43.8. So we are releasing certainly more folks than we are detaining. Looking again at national versus Maryland, we have 378 people as of the last time we looked in September of 2024. It's a little low for us. Generally, we're a little bit higher than that. Average number of days detained, 445, but our median is 1 year. So I'm not a math guy, but median is middle, right? So we have just as many people detained for longer than a year as fewer than a year. The percentage that are charged with crimes of violence, 33% in Maryland versus 19% nationally. What that means is we have more significant crimes are being charged even in our small state than in most other places. Again, I think that is largely driven by Baltimore City and all the challenges of that. The percentage of high-risk cases, so pretrial services will grade someone based on risk factors using all of their kind of national data. We have 37% of our folks are so-called high-risk cases versus 38% the national average. But our release rate for those folks is 32% versus 20%. So we're letting more higher risk folks out back into the community pending trial. Now, our violation rate is 20%. And you could say, well, that's pretty high. The vast, vast majority of those violations are what we call technical violations. Somebody tests positive for marijuana, that's a violation. Somebody gets late, 2 minutes late to the curfew, that's a violation. Somebody has permission to go to the dentist on the way home, stops at the post office, unauthorized stop, that's a violation. Those folks will not be detained typically for those violations, but that's usually what kind of raises the flag. I would say more often than not, I will get a note from pretrial services. Judge, just to let you know, there's been a violation. We're recommending no action being taken. Now, we do have folks who do incur charges. Again, they may or may not actually ever get convicted of those charges. Often, especially in the state system, charges get dropped. This is a little higher than the last time I looked. So this is 2024. The last time I looked in I think it was 2022, for the year, we had no one incurred felony charges, and we had more people on release. So this has ticked up a little bit. What difference does it make? Obviously, it makes the difference to the person being detained, but there are some other ramifications. The family, this person may have been the breadwinner or a key member of the family in many respects. With their detention, the rest of the family will face significant challenges. The cost is obviously much more. $41,000 almost to detain somebody versus less than $5,000 to have them on community release. Sentencing. Now, if you are detained, you do get credit towards the sentence. But if you are successful on release, even though you don't get credit towards your sentence, that is a factor in computing your sentence. So being successful on release can be important in terms of how much time you get. Other risks, you have a greater likelihood of getting a custodial sentence in terms of not getting probation, but actually sent to prison. You will get a greater length of sentence. There is increased recidivism. It's almost twice as likely if you are detained more than a month. Even if you're detained only a few days, your risk of recidivism goes up. Now, is it cause and effect? I don't know, but it's certainly at least a correlation. Again, either side may appeal my detention decision to a district judge. They look at it de novo, so they're not bound at all by my decision. It's relatively rare for them to appeal. It's almost more rare for me to get reversed no matter which way I go. Questions, comments? Yes.
Like such as, oh, okay, thank you. You mentioned various ways such as like visiting the detention center.
Yep.
That like helps you consider the like weight of your decision. And I'm wondering if something like that is required for you and fellow judges. And if it's not required, is it like common practice anyway?
I will say among my colleagues, I have found it to be common. I don't think that it's required because I know that I asked for it. So it wasn't kind of part of the orientation, so to speak. But I thought it was important. And I think, especially these days, I think my colleagues have all done a similar visit. Yes.
Thanks for being here. You mentioned quite a few times at the beginning of your presentation, sort of the importance of good faith, sort of in the system, these good presumption of almost good faith, these good faith actors, right, the attorneys, et cetera. And I'm sort of thinking now, as I look at, frankly, sort of like a constellation of malign actors installed at DOJ and FBI, to name just a few agencies. I mean, how strong is this check from the U.S. Attorney's Office on, say, a warrant that's being pushed from, I don't know, like from FBI headquarters, let's say, to go after like a political appointee? I mean, do you think that you would ever see a warrant in front of you that's clearly just sort of an attempt to go after a political opponent? I mean, I know you can't really speculate, but how strong is the check from, I suppose, Maryland's attorneys?
I can't really speak to how many things they get that they push back to kind of DOJ proper on. But in terms of what comes to us, I mean, look, it's got to be a valid crime. There has to be the potential for evidence supportive of the crime, and they've got to meet the Fourth Amendment. And I see that, across my colleagues. And I also think that, again, I can't speak for everybody. The line prosecutors, I don't say that they can always get fired, so they're not impervious to it, but I get the sense, particularly those who have made a career of it, they will push back where they need to push back. But yeah, the system is built on that. If that goes away, and then when we see instances of it, right? So we have in the gun trace task force cases, if you have officers planting evidence, lying about search warrants, I mean, I don't have really any way of knowing that. So, when we find that, that's why it's so upsetting on many levels. That can always happen, I suppose. I can only say that, here in the third branch of government, we're very vigilant about that. But we'll stay tuned. Anything else?
Thank you. Yeah, you spoke at the beginning about, good faith and faith in the system. Certainly, it seemed that public opinion has started to sway about how people perceive the justice system. In your experience, have there been more people that are hesitant to accept counsel and that are trying to represent themselves? And how do you deal with that when that comes up?
So I haven't seen an increase in that. That does happen. I think our federal public defenders are very good about building trust and how to do that. Occasionally someone will force the issue. If they want to represent themselves, they can. We have we call it a Feretta hearing after a case. We will have a hearing with that person and we will do our best to point out all the problems with doing that. But if at the end of the day, they want to make that decision, they will. Even in those situations, we will normally appoint what's called standby counsel so that somebody's there for them to consult with, in case they run into a problem. Honestly, I don't think for most of the crimes that we're charging, again, this is, these are drug and gun cases. I don't think there's kind of a political lens that most of the folks who are swept up in that kind of don't have time I don't want to say luxury, but they're not thinking about that. They're thinking, this morning I was in my bed and now I'm, locked up with a U.S. Marshal Service. But I haven't seen a change, certainly not a change yet. Occasionally we'll have folks who have very strong, sovereign citizens or folks who have their own ideas about the government. I don't want to paint with too broad a brush. Generally speaking, those folks are coming to us with different kinds of crimes, like, making bombs in a basement or something, or saying something, threatening some violence against a political figure or something. But it's not common for us. It may be more common in other jurisdictions, though. Other questions?
Along the lines of like the DOJ bringing charges that aren't valid, I've been thinking about the DOJ dropping charges on Mayor Eric Adams and how, as a federal judge, you can't really encourage a Department of Justice to bring charges. So as we're seeing, I guess, more executive influence over the DOJ, whether it's charges being brought or charges being dropped, how do federal judges kind of stand in that place of advocating for the separation of powers?
So on the dropping the charges end, by the time it would get to that, it's sitting with a district judge. My understanding, I have had conversations with them recently about that if the government wants to drop the charges, there's not a lot of ability for the court to say, no, you're going to prosecute the person anyway. So I think we're gonna have to wait to see. That is unprecedented, at least at scale. So we'll have to see what the reaction, but as you saw in the U.S. Attorney's Office, it was those line prosecutors, who said, we're not going to do that. This is not something we think is proper. And of course they wind up resigning and finally they find a person to do it. We'll have to see that, if we see more of that.
I think that's all the time we have for questions. I just wanted to thank Judge Coulson for being here with us today. Thank you all for being in attendance and for asking such great questions. Please help me give Judge Coulson a round of applause.
So thanks, everybody. It was great to be here. Great to have such great, insightful questions and to try to answer them. I guess I would say, if you probably knew more about my journey to this place, it would restore your faith a little bit in not only your own abilities, but that, you can have somebody who, I didn't have any criminal law background at all. I was a rich partner at a big law firm, doing just fine, and came into this world with absolutely no background, all the implicit and maybe even explicit bias that one might think of somebody in my age group and other demographic characteristics. However, I always wanted a fair fight.